Let everybody come in. All right. Good afternoon, everyone, and thank you all for joining us for today's month of service presentation of I Need Civil Legal Representation. What are my options? My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today is Ms. Myra Hippolyte. Also, on behalf of our partner with the Houston Bar Association, we have our presenter for today, Mr. Elliott Klein, with the law offices of Elliott Klein. In addition to that, we also have Lone Star Legal Aid, the Earl Carl Institute, Houston Volunteer Lawyers, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office that make up A Month of Service. And basically what A Month of Service is a collaboration of all 8 different organizations that come together on a monthly basis and offer a variety of different workshops, resources, and information relative to community empowerment, asset building, and asset protection for the purpose of maintaining generational wealth. In addition to that, our collective, our collaboration has been working together for the past several years due to the fact that we all service the same community and we wanted to create a larger impact and get more information out to different communities as a whole. So we decided to come together, but of course we've had to transition to the virtual platform, which has actually allowed us to reach even more people around the county, surrounding counties throughout the state of Texas, and just about everywhere else that you can think of to provide this information. We know that many communities do not receive or don't know where to go for different resources about information. Where do they go when they have basic questions about certain things? So we wanted to make sure that there was a space for the community to be able to reach out and get that information that's actually free to the community. So we want to welcome you all again and thank you all for joining us for today. Also, if there are any attorneys that are joining us on behalf of the Houston Bar Association, if you see any course numbers outside of our presentations, you have the opportunity to receive free CLE credit for participating and viewing this presentation of A Month of Service workshop. In addition to that, information that is presented during these legal workshops are considered educational purposes only and are not considered to be legal advice. However, we do encourage you all to reach out to our legal service partners to receive some assistance with any civil legal matter that you all may have. This is an opportunity for you to ask questions. We do have the professional here that's going to be providing you guys with the information. So feel free to ask whatever questions it is that you like. However, we do want you to keep in mind that we are streaming live on our social media platform at Amos Houston TX on Facebook, as well as recording the session. So we want to make sure that we try to protect your privacy as much as possible. So we ask that the questions that you ask to try to be as general as you possibly can. So that way your personal detail information is kind of not getting out there for everybody to have access to. In addition to that, we don't want to get into too many details about your specific situation, because then you're kind of getting to the territory of getting legal advice, and we're just here to provide information. So try to keep your questions to be as general as you possibly can. So with that being said, feel free to type whatever questions that you may have into the chat to either one of us. Also, if you're joining us on Facebook, feel free to type your questions into the comment section. Participants on the Zoom call will also have the opportunity to unmute yourself or raise your hand and wait till the end of the presentation and ask questions directly of the presenter. So please, we encourage you all to do that. So with that being said, we are going to introduce our partners and our presenter, and we are going to move right on into the presentation. So there's a lot of information to be covered here today, and we hope that you all receive the information that you've come here to get. So let's move on forward. So Ms. Myra, would you like to introduce yourself?
Thanks, Ms. Nia. Good afternoon, everyone. On behalf of Mayor Sylvester Turner and Director Takasha Francis, we want to welcome you to the Month of Service partnership. This partnership is all about giving back free information to all the Houston, Harris County, state of Texas, and come to find out even some other countries. There's people from other countries coming by and joining our virtual workshops. So guys, this is all about giving you free information that whenever you're going through any type of stressor in your life, you know that you have a team of partners, just like Mr. Elliott, just like Ms. Nia, Neighborhood Recovery, just like the City of Houston Department of Neighborhoods. We're here to assist you with whatever concerns or issues that you have. You know what, we are walking right by your side, but one of the things is that we are not holding your hand, and that takes you. So for you to take that big step and that big leap and to attend our virtual workshops, because the only way you're going to get educated and in whatever stressor you're going through, step 1, step 2 is to attend all our virtual workshops and be a partner, a participant in this amazing partnership. Thanks everyone. Have a great day and stay safe. Thanks, Mr. Klein.
Not a problem.
Okay, Mr. Klein, would you like to introduce yourself, and then we'll move right on into your presentation?
Sure. Go ahead and let's have the next
Okay.
screen up there. Okay. So my name's Elliott Klein. I'm an attorney. Let me give you a little bit of the background. Originally, I was born and raised in New York City. I got my undergraduate and law degree at the State University of New York at Buffalo. And then I came down to Houston. I've been here more than 30 years, and I'm admitted to practice in New York State. I practiced there about 2 years before I came down here, and Texas and Oklahoma, and in the federal courts in the Southern District and the Eastern District of Texas. As far as my background goes, it's been pretty varied. I've worked for insurance companies for about 12 years, including Kemper Insurance for their staff counsel for 7 years. I did oil and gas work, mostly in East Texas, for about 10 years. And for about the last 10 or 15 years, I've been in private practice here in Houston. I've been active with the Houston Bar Association. I give talks like this before community groups and schools probably 3 or 4 times a year. My practice is primarily, I do mostly insurance. I represent policyholders, what they call first party insurance claims. That is when people have problems with an insurance claim, and either the insurance company will deny the claim or will limit the recovery. I'll represent mostly individuals and also some businesses on insurance litigation. I do a lot of real estate, mostly on the probate side, straightening out bad title when you have heir property, when people haven't had wills for generations and they want to sell the property or they want to borrow on it and the title is not straight. I'll be doing that. Of course, I do wills and I do probate and some personal injury. So I'm fairly active. I have an active litigation docket. So let me go ahead and we'll proceed then. Next screen, please. Okay. So basically, I'm going to be dealing with issues about civil law. Now, of course, the law is just a huge, how can I put it? It's just a huge field. It is expansive. But the major difference is between criminal law and civil law. What criminal law is involved, of course, there's got to be a violation of a statute, and the punishment is basically restricted to restricting a person's physical movements, the punishment. And that could be at the arrest stage or in a punishment stage, and put in county jail, maybe prior to trial if you can't make bond, or if a person is convicted, they'll go either to the county jail for some offenses, and for more serious offenses, they'll go to the state prison system. So it's all about restricting, the punishment is basically just restricting your physical motions and also taking away your civil rights, because there are restrictions. If you're a convicted felon, you can't serve on a jury. There are limitations while you're still serving your sentence or you're on probation, you cannot vote. And I'm not going to be dealing with that. I'm going to be dealing with civil law. Civil law deals mostly with money. When there's a dispute about money, it could be contracts, it could be probate on how an estate is divided up, and it could be fraud. That's basically, or in divorces, you're dividing up property. So it's all about property and it's all about money. Now, there are some situations where the civil courts can, a judge can make an order ordering somebody to do something or not do something. If you have like a patent violation or restricting a certain kind of a business activity, but most of the time, the disputes are over money, and the courts will render a decision how the money should be divided or what kind of an award should be. In situations where where the courts enter orders about what a person can do or not do, could be child custody, who has custody of the children, non-compete agreements, a return of property that might have been taken unfairly, or to receive contested property. Sometimes there are people, there might be money in an account, and there are two or more people are making claims on that money. The court will make a decision about where the money or the property should be divided. Next, please. Okay. So I'm gonna, the civil law is done, it's huge volumes. That's basically where the statutes are. There's also what they call court common law, which is law that is made by the judges. But for the most part, for regular folks who have got their day-to-day lives, who aren't multimillionaires, the common areas of civil law, where court action affects our daily lives, probably the most common thing is the motor vehicle law. That is not necessarily, that's not a criminal violation for the most part, as far as like speeding goes, or for going through a red light, or that's basically, it's a big area. The next area, most common area, is family law. Divorces are extremely common in this society, and in order to get a divorce, you have to go to court to get a divorce. And then there's all sorts of disputes involved. There's custody, there's support, and there's division of property. Personal injury is also another area, common area, where it will affect our lives. Most of the time, we come across this if there's an automobile accident where your car is damaged or you have personal injury. And there's got to be a determination of who's at fault and what the damages are. Probate is another big section, and that would be wills and estates. Basically, it's if you have a will, you can make your own decision about where your property will go after you pass away. And if you don't have a will, then there's intestate succession, where you still have to go to the court to get a determination of who your heirs are and how the property is to be divided, who will be the executor of the estate. Again, all these determinations are made by a court order. Collections would be if let's say that you owe money to somebody for one reason or another, credit cards, let's say, or you've signed a note for something and you fall behind. The person who is the creditor can bring suit against you. Or if, let's say, you're a tradesman and you're doing work for somebody on someone's house to do home improvements, if they don't pay you, you can go to court to collect money against the homeowner. Or if there's a dispute about that maybe that you have paid a contractor to do work and they haven't done the work, successfully or to your to your liking, you can go ahead and you can sue basically for that. City ordinances are another big area of civil law. If you don't keep up your house, if you don't mow the lawn, if your car is parked in front of your house for too long, there are all kinds of city ordinances, or to get building permits, or if you don't have a building permit, there are all city ordinances that control this, and that can be enforced by fine, usually rendered by the municipal court. Juvenile law is another big area. When children who are minors, when they commit crimes, there's a whole separate section. It's criminal law, but it doesn't stay with you after you become 18. It's considered, there's a lot of civil law. Kids can be taken away from their families. You have child protective services that can determine who has custody of a child, and the foster child system. That's basically, there's a whole area called of juvenile law. And all these are civil. These are non-criminal proceedings. Next, please. Mia? Okay, so I'm going to start out with the kinds of courts. There's different levels of courts. In Harris County, I think we have probably anywhere from 50 to 100 courts. It's a huge amount. Mia, I'm on the slide with the courts. That's good. That's good. It gets it's overwhelming, the number of courts, because the problem is in Texas is that we vote for everything. So all these courts, for the most part, when you go and you vote, you can be presented with a choice of voting for maybe judges in maybe 50, 60, 70 courts. It gets really overwhelming. But the basic divisions is municipal court, which is the lowest level, and usually they're appointed by the city council. And that will handle things like traffic violations and city ordinances. Justice courts, that's called the JP court or small claims courts. These are elected positions. We have various precincts in the county, and each precinct may have one or more judges. They handle relatively small things, but the most important thing is evictions. And that's been real big news for the last couple of years. When if you have a tenant who doesn't pay the rent, the landlord can evict them, and there's a procedure to do that. And they usually with the constable, but you have to get notice, you have to have a hearing, there has to be a judgment. Small claims court is disputes, money disputes, but that's limited to $20,000. And that's actually a fairly substantial amount. You have a lot of disputes with tradesmen who don't get paid, or neighbors that may have problems, who's going to put up a fence, let's say. But that's relatively small things. The nice thing about justice courts is that you don't need a lawyer to present your case. It's a more informal procedure. It's kind of like if you watch Judge Judy on TV, that is how small claims courts operate. You tell your story, you don't need a lawyer, you just tell your story in your own language, the best that you can. The evidence procedure is very relaxed. You can just, basically letters or emails, or I've seen people will hold up their cell phone to show evidence of communications back and forth. And the judges, they're pretty easy. They're easygoing folks. It's most of it, you're entitled to a jury trial, but most of the time you tell your story to the judge, and the decision is made on the spot for the most part. And you can get from filing, you can usually get a hearing within, I'm going to say 6 months, which is actually very short for a judicial proceeding. And I tell a lot of people call me with all kinds of problems, relatively small things, and they say, oh, I want to hire an attorney. And I tell them how much an attorney is going to cost them. And I say, look, for $150, you can go down to the JP court, you can file the petition. It could be, and they give you a form that you fill out handwritten, what your problem is, you name the defendant, you name their address, and it will be processed, and you'll get a relatively quick decision. If you don't like the result of what the judge says, or if the other person doesn't like what they said, didn't rule in their favor or didn't rule in your favor, you can then appeal that to county court, and that's a more involved procedure. The next level up in Harris County is family courts, and they have specialized county courts. Some of them have general jurisdiction, but they have specialized county courts for family law, which will handle, of course, divorces and custody and support and property division. You have specialized county juvenile courts that will handle all the disputes that deal with minors. And if there are problems, if they should be taken from the home, if they should be put in the foster system, that's what's involved with there. The civil cases are the jurisdiction is higher. The justice court was 20,000, and the limitation for county courts is 250,000. You'll see a lot of collections, credit card collections, let's say, in that. The district court is the highest level, and that's unlimited jurisdiction. That means just about any case can be brought. There's no limitation as far as money amount. District courts will also handle tax cases, and they'll handle judicial foreclosures as well. So that's basically what it is. And like I said, I think in Harris County, there's probably, between all these four types of courts, there's probably 100 courts involved. Next, please. Now, in addition to actual courts where you have judges, we have judges that are appointed or are elected. There's another huge area of civil law, what I call administrative law or compulsory arbitration. These are various state and federal departments that make decisions and deal with disputes, and are not courts, but they're set up as administrative hearings, and they'll have and they call it administrative law judge. These people are not elected; they're appointed, or they're civil servants basically. And some of the biggest example, of course, is Social Security, and where you get disputes in Social Security is not when you're 65 or you're 67 or if you're 70. But if you become disabled and you can't work at a younger age, and you make an application, you say that there's provision that if you are unable to work, you're still entitled to a certain level of benefits under Social Security disability. And this is a big area. There are dozens and dozens of attorneys that just specialize in this. And if your initial application is turned down, you can appeal to the administrative law judge in their various levels, and they have various procedures. And there's it's all about benefits. Do you qualify for benefits? If, let's say, you've received your benefits and then you are able to work, you're basically entitled to a certain level of benefits for a certain period of time, even if you can work, because they're trying to encourage people to return to work. But the benefit scheme is very involved, and if there are any disputes, then you will go before an administrative law judge. Unemployment insurance is another big administrative law area. Of course, if you're laid off because of economic reasons, you are entitled to your benefits, to your unemployment benefits. But then there's a question about did you lose your job for a cause or for some bad act, or were you laid off for economic reasons or not economic reasons? So there's a lot of disputes if your applications are rejected. And again, they have an administrative law procedure where they have hearings where you can have evidence and an appeal process. Of course, we all know property tax, property appraisal districts. Each year we get an evaluation of what our property is worth and what the tax levels are. And you can appeal if you think that you're being appraised at a too high a level. and they have hearing procedures. Again, this is administrative law. Building permits, same thing. Whenever you ask something from the government, some kind of a benefit, one way or the other, and there's a dispute, if let's say you're rejected, the departments are required to have a procedure where you can appeal and present your evidence and make an argument. Yeah, homeowners associations. Now, this is not exactly a governmental thing, but homeowners associations, they're huge. They're a huge part of people's lives. And so the biggest thing with homeowners associations is if you are in violation of the deed restrictions, or if you want to make an architectural change and you have to get approval from the architectural committee and they can pass judgment, the law requires the homeowners associations to have a procedure to appeal if the Board of Trustees denies your application for an architectural modification. And it's the same thing. You've got notice, you've got evidence, you've got a right to present your case, to cross-examine, and arbitration panels, which is really huge, because virtually every contract you sign, every credit card that you apply for, every movie ticket you buy, every sports event that you go to, every car that you buy, any kind of an app on your cell phone that you make an application for, just any kind of activity on your phone where you're making an application, basically on the apps. If you read the requirements there, but before, when you're making the application, it says you got to read this and you got to check that you have read it. And usually it is dozens of pages and virtually nobody reads it. You just can't read it. I mean, it's just incredible. But hidden in there is that if there is a dispute between you and the provider, that you give up your right to go to court, and you have to submit to what they call an arbitration panel, which are people that, and there's a procedure for selecting one or more arbitrators who will hear the matter, will consider the evidence, and they act as courts, absolutely as courts. And the procedures are all spelled out in the application or in the contract that you're signing. If you have a home improvement contract, if you're buying windows, let's say, or any kind of service or around your house, and you're signing a contract, you read in that 90% will have arbitration procedures. That is in lieu of a court procedure, and you're giving up your right to a trial. You're giving up your rights to class actions, all kinds of stuff. But the alternative dispute mechanism is spelled out in there. So, and this is all part of civil law. And now all of these adjudication proceedings are all regulated by the same general principles that we call due process. It's something that we're taught in law school, and it's basically a dispute resolution procedure. It's called due process, and due process consists of a number of items. Nia, next. So the general outline of due process, or the legal process, is number one, you have a notice of claim. If somebody has a beef against you, if, let's say, as simple as they're making a claim that you caused an automobile accident and you caused them damages, it's basically a lawsuit, and the lawsuit, the petition names who the plaintiffs are, who the defendants are, what their cause of action is, what they're asking for. If let's say you're denied benefits for, let's say, Social Security or for unemployment insurance, you can fill out a claim, or if you're appealing, let's say your property evaluation, your assessment. So what you do is you file a claim, you file it against somebody. It could be an individual or it could be an organization, and then the person who you're filing against is required to respond. Usually what they'll say is they deny the claim. And then that's the obligation to timely respond. In a regular lawsuit, typically, if let's say you get sued for something, and I'll just give you an example what you might be sued for. Let's say you have a neighbor and there's a dispute about a fence, that the fence is encroaching on their land, let's say they say. So they will hire an attorney most of the time, and you will be served with a lawsuit, and it will talk about who's filing it against you. It'll say what their claim is against you and what they're seeking. And once you receive that, usually it will be served by a constable or a process server. Once you're served with that, you have typically, it's a little bit more than 20 days. It's the first Monday after 20 days is from when you've been served. You have if you have an obligation, if you want to defend yourself, if you want to tell your side of the story, you have an obligation to respond to that complaint. And the way you file a response is you'll be, when you are served with the petition, it will say which court it's in, then and it will also say what the time limit is that you have to respond. So then what you would have to do is all you have to do is basically just write a letter saying, I deny the claim. I want to appear in court. And you could write it on a piece of paper with your name and your address. And you can go to the court where it's pending in and hand it to the clerk. And then that will hold up the system and prevent what they call a default judgment. You could be sued for, let's say, for credit card debt. The same kind of thing. You will be served. Or an eviction. They'll post something on your door. That's the eviction notice. But it will give information. It'll give who's suing you, what they're seeking, which court it's pending in, and it will say the date that you have to respond. And the biggest problem I see here, or in the divorce proceeding, one of the spouses will go to an attorney, or maybe they might fill out the petition themselves, because some of these petitions are available in the clerk's office for people to actually just fill out themselves. You'll pay the fee. They'll have to pay a fee for service. Constable, again, in the legal proceedings with the courts, you will usually be served by a constable. Now, you might be served also by a certified letter, and that's as good as service. Now, the big problem that I see with just regular folks on these things is that if they're not too sophisticated, number one, they'll ignore the pleading. They'll look at it, they don't have no idea what's going on here at all. And if they ignore it and they don't file an answer, then the other side can automatically get a judgment against you and get whatever they want. So the most important thing is if you get served with some kind of a court paper or even administrative law paper, and that might be Social Security, or it might be unemployment insurance or something. If you get served with papers, and I get calls all the time, I got these papers, I don't know what this is. And they'll want me to answer. The first thing I have to say is, you're gonna have to show this to me. Or they might go on with a long story about, this isn't fair, I paid off this credit card, and why are they suing me, and blah, blah, blah. But I'll have to say, number one, when were you served? What was the date that you were served? Are the 20 days up? And then what does it say? And a lot of people just cannot read the gobbledygook, and I can't blame them. I can't blame them at all. I file lawsuits all the time, and some of my lawsuits are 20, 30 pages. And if you're not an attorney, you're probably not going to be able to figure this out. I once served a person, and instead of going to an attorney, they called me up. I mean, I'm the opposing party. They called me up and they say, what's going on here? And I have to tell them, I am not your friend. I can't give you any kind of advice. So the main thing is, if you get served by these papers, if you don't understand them, if they're not, if you don't understand them, go to an attorney. Gosh, please go to an attorney. And because virtually all attorneys are familiar, I can't say all, but the vast majority are familiar with these kind of processes. Pay $100, pay $200, get some advice. Even if the advice is, you're being sued for a credit card debt, or you're being sued for a note on a car loan, or you're being sued for the furniture that you bought on time. If you've got a story, if you want to defend yourself, you have got to file a timely answer with the court. And once you file an answer, the court will inform you if there are any upcoming hearings where you can tell your story. So the main thing is don't ignore it. Also, don't ignore certified mail. People are scared of certified mail. They think that, somebody wants something from me, I owe taxes. It's bad news. I'm being notified that I did something wrong at work, and they're going to fire me, and I don't want to know about it. Or somebody's filed a complaint about something, and people do not pick up their certified mail. If you're living in a house or an apartment, you're going to get a little card that says you got certified mail or you got priority mail. Come to the post office and pick it up. And people, and I've seen lots and lots of people, number one, if they know what it's about and if they know they don't have a defense, they want to ignore it. A lot of people will just simply ignore it, especially if it's from the IRS, because they're scared. They're just terrified. They think, I can't do anything about this. But you've got to know what's going on. So when you get the card in the mail, the problem is you got to go to the post office. And sometimes it's not the easiest thing in the world to go to the post office. You have to drive 3 miles. They're not open on, they only have certain hours. You're going to have to take off some time from work. It's going to interfere with your daily schedule as far as delivering the kids to school. A lot of people just ignore the certified letters or the priority mail letters where you have to go to the post office to pick it up. I've seen a lot of that. But to protect yourself, you've got to do it. You got to face the music. That's really what it's all about. You got to face the music. Maybe you can do something about it. Maybe you can't. But you better know what it's about. Once you get it, once you get this document, if you don't understand it, go to an attorney. And you can say, well, what attorney? What attorney? General practitioners will handle these kind of things. These are like ordinary people's problems. And virtually, if you go to someone who's a tax lawyer, they probably won't know about it. But if they're people that handle traffic accidents, tickets, divorces, just ordinary, writing wills and probate, those kind of attorneys, real estate issues, those kind of attorneys, solo practitioners, handle everyday people problems, and they'll be able to help you. And initially, if they have to give you advice, they will probably charge you probably a reasonable amount. And when I say a reasonable, $100, $200 for an hour's consultation. And that will give you information where you can make a decision whether to go, or they'll give you alternatives. And then at least you'll know your alternatives, because ignorance is the worst thing. Because then in ignorance, things happen to you. You lose control. So if you get sued, and it could be, as simple as like a divorce, which, half the marriages end in divorces. So then it's up to you to take action. So the most important thing is just file an answer. And if you go to an attorney, the attorney will tell you how to file an answer, or for how do you to file it on your own. Or you can hire the attorney to do that. I'm not going to give you, say, you can file an answer. Just send in a letter and say, I contest this claim, and I want to be notified of a hearing. I can tell you that, but for someone to actually go through that and do that, that's another link. Some people can handle it, but they're a minority. And then once you file, or you have an attorney that files an answer, the good thing is that you will be notified of the proceeding, of the hearing. Now, like I said, if it's in justice court, which there are a lot of things there, you don't necessarily need an attorney. But at least go to an attorney and get some advice, what the procedure is, what you need to do. You may not have to bring the attorney to the hearing, but then that's a more expensive procedure. But when you sit down, he or she will give you an outline of how, what's going to happen, what the conduct will be. And my advice to folks is, if they can't afford to hire me for my regular hourly rate for hours and hours and hours, if it's a small amount, I will give them advice how to proceed in justice court. And basically it's relaxed. It's Judge Judy. You watch on Judge Judy, you'll get a really good idea of how justice courts operate. You can bring whatever documents you want. You can bring your friends. You can bring your witnesses, basically. It's really informal. And the judges are more like Solomon. They got a lot of common sense, and they are not required to follow the rules of civil procedure. It's much more relaxed. So most things in justice court, and there's a lot that goes on in justice court. So don't be afraid of that, especially if you have a story to tell. And it's your responsibility to bring the evidence. It's not going to be a he said, she said thing. You've got to bring, when I say evidence, documentary evidence, emails, or bring your cell phone and say, these are the discussions we had. This is what this person said. This is what that person said. That wouldn't pass the rules of evidence in district court, but in JP court, they will consider all of that. And a lot of times in JP court, what's nice is they really want people to work things out for themselves. So I've been in JP court many times, and it's like, you tell your story for 5 or 10 minutes, the judge has got an idea, he makes a suggestion, he says, look, I got 30 other people here I got to take care of. I want you to go in the hallway, or I want you to go in this room. I want to see if you can work it out on your own. If you can't work it out, you're going to be at the end of this line of 30 people, and you're just going to have to wait for me to have my time so I can hear the rest of your story. And 90% of the time, people work things out. That's and believe it or not, that is really how it works at all the levels, at JP court, at county court, at district court. And why do I say that? Because it's just more formalized in the higher courts, in the county court or in the district court. 95% of the cases that I handle, you go through the whole rigmarole of discovery, where attorneys are involved, of presenting evidence, because in all litigation, in heavy duty litigation, automobile accidents, breach of contract actions, insurance claims actions, you have to exchange the evidence. You have to exchange all the documentary evidence that each of you have. You're required to do that by the rules of civil procedure. And then you can take depositions, which can cost thousands of dollars. You're going to have motions. You're going to have summary judgment motions, motions to exclude, all kinds of stuff. It'll go on for 2 or 3 years. And 3 days before the actual trial, the case will be settled. I just got done with a case 2 weeks ago. We were in litigation for 4 years on a contractor fraud action. I sued the contractor and I sued the referral company, and we went back and forth. And of course, COVID jammed everything up for 2 years. But after all that, and then we went to mediation, they wouldn't offer any money. It goes on and on and on. And then 3 days before the jury trial, boom, we settle. So that's really how litigation works. Now, of course, at the higher level, you really do need an attorney, because you're going to be up, especially if you're up against big commercial firms or big insurance firms. That's really when you need an attorney, either on the prosecution side or on the defense side. All right. Now, the other thing is that in JP court, it doesn't have to be conform with the rules of evidence. On the upper, on the higher courts, in the county courts and the district courts, it does have to comply with the rules of evidence. You just can't come in with a piece of paper, wave it around and say, this is what this says. If it's a business record, you have to get an affidavit that says it's a business record, or you have to have someone who testifies. If it's a picture, you've got to have someone who testifies that it's an accurate picture. If it's medical records, you need you need various prerequisites to get it in. And for that, you really do need an attorney. Next, please. All right. Now, I was talked a lot about the legal process. You have a right, and when I say you, it's either you or your attorney. But even in justice court, you can ask the opposing side to produce various documents. It's limited. Their rules are rather limited. You have to get approval from the judge to ask the other side for their documentary evidence. And usually the clerk in the JP court will give you a form that you can fill out for that. A lot of the stuff applies when I say you, it's the informal thing about the justice court. So in justice court, you have a right to examine the person who's making a claim against you and ask questions. And you have rights to question their documents if they're presenting something against you. If, let's say, you're being sued for, you bought something on time, let's say, or your furniture, and the other side will present a contract. And if you have a right to ask for that contract ahead of time, you have a right to ask for, let's say, a record of the payments. And at the time of the trial, you have a right to cross-examine the representative of the company who's presenting this evidence, if there are some inaccuracies or discrepancies in the documents that they're presenting. Of course, you have a right to attend the hearing, whether it be JP court, county court, or district court, give your version of the story and bring in your own witnesses and documents. Next. Oh, one other thing. In all the court proceedings, you have a right to appeal. If the judge or the jury enters a judgment against you, you have a right to appeal. So in JP court, if, let's say, it's an eviction proceeding and the landlord gets a judgment that you have to evict in 5 days, that's typically what's going on, you have a right to appeal to the county courts. Now, you have to post a bond and you have to keep paying your rent. But if you have a story where you think you have a legitimate reason for staying and that the eviction was wrong and the judge ruled against you, you have a right to appeal. In the county court and the district courts, if the judge makes a ruling against you or your attorney, basically, you have a right to appeal. So I have a story about that. This was an insurance claim. My client, he had a fire at his house and he had a building that was under construction, that was attached to the house, but it wasn't completed yet. And that building, the outbuilding, burned down. And the insurance company limited the recovery to 10% of the homeowner's policy because they said it was a building that was not attached to the main structure. But we're saying that it was attached because the addition was under construction. It wasn't completed. So the insurance company said it was not attached. And we're saying that it was attached because the construction had started. And so we filed suit. We were in district court. The other side filed a motion for summary judgment saying the evidence that's there shows that it's clearly not attached. It's a separate thing. And without even having a trial, the judge granted the summary judgment, which knocked our case out completely. And then we appealed it to the Court of Appeals. This was in the middle of COVID. It took a while, but the Court of Appeals, looking at the same evidence and hearing our argument, reversed the judge's judgment and gave it back to the court and said, no, you can't throw this case out. You're going to have to keep going to a full trial on this case. And that's part of the judicial process of appeal, even if the initial judge rules against you. And that applies also to the administrative proceedings. In workers' compensation, if you make an application and the hearing officer at the contested case hearing finds against you, there's an appeals panel that you have a right to appeal to. On all administrative proceedings, you have rights to appeal. Appeals are usually just based on the documents that were introduced at the trial level. So that's part of the legal process. All right, Next screen, please. Okay, so the question really is, do you need a lawyer? Like I said, for JP Court, a lot of cases, not all cases, but a lot of cases, the amounts are relatively small. Somebody sues you, your neighbor sues you for your kid was throwing rocks and broke his window, and it's $200 to replace the window, and so your neighbor sues you for not supervising your kid, or maybe the dog got out and bit somebody, and so whoever it is, they've sued you. And if it's small amounts, a few $100s, maybe even a few $1,000s, or there's a dispute with a business that you paid money for an item and the item was defective and the store wouldn't take a return, and so you go ahead and you file something in small claims court for $1,000, let's say, something like that. And the question is, do you need a lawyer? So for small amounts, let me get rid of this here. For small amounts, you can tell your story, because the hiring a lawyer is going to be more than the small amount that's in a dispute. So typically for small amounts like that, you tell your story, and you may win, you may not win, who knows? But at least you can handle it on your own in the informal setting. But once it gets to a higher level, or for administrative proceedings, or let's say you have a dispute at work where you're being accused of some misconduct, let's say sexual impropriety, something that you were harassed, somebody is claiming that you were harassing them for sexual impropriety, and you might lose your job, even though it's an administrative proceeding. When the money is big, that's when you need a lawyer. That really is. So you have to evaluate, if you lose, what's at stake? And will this impact your, number one is your ability to obtain and hold a job. So almost all of the HR problems that someone might face, I would definitely say you need a lawyer. Absolutely need a lawyer. This is not something, because otherwise you're just going to go in like a babe in the woods. You don't know the ins and outs. You don't know what procedures there are, because they could be very, very involved or very opaque. And so you need someone who's been there before and who has experience in that field, and that would be a lawyer. So if you can, if your job is at stake, if your income is at stake, if your standard of living is at stake, if your relationship with children and family. So, but this is in for divorces. Many divorces are what they call amicable divorces. The people realize they can't live together. They have children. They love their children. They want to take care of their children, and the major breadwinner realizes he or she has an obligation to support the kids. A lot of times they can work things out for themselves. You may not need a lawyer there, but if there's a fight over custody, you need a lawyer. You're not going to go, especially if the other side has one. You do not go, like they say, you don't take a knife to a gunfight. You've got to be on equal levels, because there's a lot at stake here. Also, if child protective services is involved, or if there's juvenile law where you may lose custody of your children, this is relationship things going on, you've got to give it all. You've got to make every sacrifice in the world to make sure that you're on an equal footing and that you have half a chance. You need a lawyer, something like this. Of course, if your career, if your home is going to be foreclosed on, if you have, and it's important to you, if you have equity in your home and maybe it's going to be taken away by some flim-flam kind of a situation. I've seen lots of solar panel schemes where people will spend $70,000, $80,000 for a solar panel. They've got a 30-year mortgage on that, and the darn thing doesn't work. Something like that, and there's a mortgage, and there's a lien on their house. definitely you need a lawyer to get something like that straightened out. Property value. If there's, especially if you have a business and the evaluations on the property are so important and your tax rate is so important. If there are large amounts of money involved, you need a lawyer. So basically, the more money that's involved, for sure, on the money side, you need a lawyer. And relationships, anything to do with divorces, a lot of times with probate, you're going to need a lawyer. So, for example, I know situations where there are a number of children. Maybe there's a will, maybe there's not a will, but the person who is going to be the executor, nobody trusts. They have real suspicions about the person who's the executor. They don't think they're going to do a good job. They think they're going to be cheated out of their share. Where large amounts of money, or even small amounts of money, if people have lost faith, especially with the probate and the executor or a trustee, and the emotions are high, and it's something you're going to have to live with for the rest of your life. Yes, you need a lawyer. So what I say is, if there's going to be this money impact or career impact or reputation impact or family relationship impact where there's a dispute, or probate where there's a dispute, that's when you need a lawyer, where the emotions are high. Next. So now, let's see, this is where the rubber hits the road. I get calls all the time saying, I want to sue so-and-so. They disrespected me. A cop, the police stopped me. They beat me up. They threw me in jail, and then they dismissed the charges. I want to sue them. Okay, you want to sue them. Do you have any money? Okay, I'm going to put it right down there. Lawyers cost. They are not cheap. Lawyers cost on an hourly rate. We're probably looking for regular, even just, I'm not talking about representing a corporation. I mean, corporations have money and they will pay $600-700 an hour to attorneys to, where big money is involved, and because they've got millions of dollars. But for average people, let's say you've got a job, you're making $60,000-70,000 a year. Maybe you have a husband and a wife, maybe their income is $100,000 a year, but their money is all gone. It's gone on the mortgage, it's gone on the car, it's gone on the school fees for the kids, it's gone on the credit cards, it's gone on the furniture that they bought on credit, it's gone on the vacations that they went to Disneyland to. They don't have, even though they have good money, they don't have a cushion at all. And that's the biggest problem. When they have a dispute, let's say they have a dispute with their homeowners association about a dispute about that the homeowners, where their homeowners association is not going to approve an improvement on their house, which is needed, and they want to fight them. Or let's say they think they've been abused by the police and they want to stand up for their rights. And they say, don't I have rights? You can't arrest me unless you have probable cause. And I say, okay, you want to fight? It's going to cost you. And even for individual problems, we're probably looking at anywhere from $200 to $400 an hour. And some people have it, but a lot of people don't. But when I get calls all the time, I want to sue so-and-so, I want to sue so-and-so. And I say, do you have an idea what this is going to cost? And they say, oh, yeah. But ultimately, if they don't have the money to come up with it, all those rights mean nothing at all. So there are some options in some limited ways where you can actually enforce your rights in limited areas, not across the board, not for every dispute, not for everywhere, this person made me feel bad or I'm scared, but the areas where you do have some alternatives for inexpensive or free legal service. The biggest one, of course, is for child support with the Attorney General's office. it doesn't cost you anything, or it costs you a minimal amount. That's what you should, of course, you should look at. The first thing, child support is important. The state wants to make sure that children have money, so they don't have to live in abject poverty, especially if the missing spouse has a decent job. And you're required to support your kids, whether you like it or not. And so the Attorney General's office is pretty good for that. Now, you may have to wait a long time. You may not get the personal service that you want. You may get a different attorney every time there's a court hearing, but at least the job gets done. So, and I think they do an amazing job. They do an amazing job. It's not the kid glove stuff. It's not the fastest or the most personal, but it gets the job done. It gets the money that you need done. And they'll handle the custody issues as well, which is really nice. Legal aid. Legal aid is limited because it's just a few people and it's spread real thin. So they have all kinds of restrictions. They have income restrictions, and they have the type of case limitations, restrictions. So if there's a fee generating case would be contingency fee thing. If there's an automobile accident, a legal aid is not going to take that. But if they have a program, if they have the grants, let's say they have a grant for straightening out titles on air property, they have certain programs. So you should always give them a call and see if you qualify. If you don't have the money to hire a private attorney, it never hurts. I mean, the worst that happens is they say no. But if you can, just go to legal aid, tell them the problem. And it's a big issue about communication because the need is huge, and the resources to help folks is very small. Maybe only 1/10 of what the actual need really is. But you got to try, especially if you don't have the money, if you don't have a choice. And the hard problem is that a lot of times you go, everything's online, of course. You can't make a phone call. You make a phone call, you leave a message, and then it's like, well, you make an application online. You have to really be persistent on these things. I always suggest be a pain in the butt. And by that, I mean, if there's a legal aid office, go down in person. I mean, if you tried making phone calls, let's say you've made 2 or 3 phone calls and you've made an application online and you haven't heard anything, rather than just slink off, slink off and feel defeated, make a pain in the butt of yourself. Go down to the office, knock on the door. Maybe they'll let you in, maybe they won't. But at least you tried. At least you tried everything that you can try. So Lone Star Legal is the big legal aid clinic here in Harris County, and they've helped people out with evictions, a lot with evictions, and some social justice things like where there's environmental contamination in neighborhoods. They have programs for that. It doesn't cover the waterfront. It's all hit and miss kind of a thing, but give it a try. Volunteer lawyers. The Harris County Bar Association has the Volunteer Lawyers Association. Now that is very limited because it's just dependent on the good graces of lawyers who are willing to volunteer some of their time. And so the Bar Association says all lawyers should take at least 1 volunteer case a year. All right. A lot of it is limited to divorces, maybe some probate kind of a thing. The Volunteer Lawyers Association, they have intake clinics. Probably, I'm thinking maybe once a month, various community centers all around the city. And you go and they'll ask for, and you'll talk to an attorney, you'll tell your story. And most of the time they'll say, okay, we'll put you on a list. And so the Volunteer Lawyers Association has a list of people that are in need, that have need for these kind of cases. And there are some limitations. Again, it can't be a fee generating case. And then it's up to the lawyers, the good graces of the lawyers in this county. Oh, I think I'll do some volunteer work. I'll take a volunteer case. And I have done it. And but it's not very satisfying because, for example, I took a divorce case, and a case that could have been settled by people agreeing to something. They'd say, "Oh, I've got a lawyer. I can fight this case," and they worked me to death. People will take advantage. Not everybody, but it's just based upon the good graces of the lawyers. They're not required to take these a case or two or three or none. I mean, they're just not required. It's just the Bar Association asks people to do it. Just volunteer work. It's like, donating to the Salvation Army. Oh, I think I'll give $100 this year. The lawyer might be making $200,000, and his volunteer, he feels that he has fulfilled his volunteer obligations by donating $100. Well, it's the same equivalent. They'll do some work, and some of the big firms require that their associates take a certain amount of volunteer cases, but it's small, one or two. So you'll have a list of 500, and every month you'll have another 500, and then every month maybe 20 or 30 lawyers will pick up a volunteer case, and they'll take something they think they can dispose of relatively quickly. So it's very, very limited. It exists, but it's limited. Now, it doesn't hurt to go to one of these intake conferences or proceedings and tell your story, put your name on the list, but don't count on it. Do not count on it. It's just something that you can do. For workers' compensation cases, they've got a great system. I've done workers' compensation for over 30 years, mostly working for insurance companies, and also as part of my private practice. Workers' compensation is if you got hurt on the job and you're denied benefits, or you're denied medical treatment, or there's a dispute about your level of disability. The workers' compensation system have employees that are dedicated to helping out the claimants. They know the system inside and out. They're very efficient. They know all the people in the Workers' Comp Commission. They know all the hearing officers. And it's not the most personal service, but it's effective and it's cheap. It's free. It's absolutely free. If you go hire an attorney, they're gonna charge 25% of your back benefits. So that's a really, really good system. Really good system. Now let's move on. That's as much as I can tell you about if you have no money at all. Now, no, I still got to talk about the retainer. Hiring an attorney. All right. So where do you get the money to hire an attorney? If it's really a serious problem, if it's your career that's at stake, or if it's your children that's at stake, you do whatever it takes. And the most common thing that I've seen is that people go into their retirement funds. It's not good, but if the immediate need is so severe, it's worthwhile. If you take out your money early, there's that 10%. You got to pay taxes on it. There's a 10% penalty, but at least the money is there. And I've had clients that have believed in their cases so much that they've gone in, and not at my not at my insistence or even suggestion, but on their part. And so this exists, but you have to make an evaluation about what's at stake, and they've done that. And there's some people, especially if it's your job is at stake, they'll use their credit cards. Again, it might, they might be held to pay, but your job is probably more important to go into debt for something like that. So the way attorneys work, there's two ways you can hire an attorney. If who you're suing has, basically, if you have a good case legally, and if the opposing party has a deep pocket, there are attorneys that will take contingency fees. And contingency fees mean a percentage of the recovery. But most attorneys are not going to take a case that there's a low chance of recovery. There's got to be, the most common thing, of course, is an automobile case where you have an insurance company that will back up the person who caused the accident. And the minimum insurance right now is $30,000. So if your case is not terribly big, I mean, if you haven't been hospitalized with multiple broken bones or internal injuries, or your leg is cut off, where the medical bills are going to be $100,000, $200,000, you can. It makes sense for a contingency fee. I said a lot of these with these contingency fees is that this is the problem. If you get injured in an automobile accident and you have health insurance, 99% of the health insurance, if you get a third-party recovery, they're entitled to their money out of that recovery. Now they can negotiate it back and forth, but when you so an attorney, if let's say somebody has $100,000 in medical bills that an insurance company has paid, and that person comes to the attorney and said, I was injured in an automobile accident, and the other side has a $30,000 policy, the attorney is going to say, any kind of recovery, most of the money is going to go to pay the doctors. And I'm not going to get anything, and you're not going to get anything. Or you might get $5,000. I might get $2,000. And I'm probably going to, it's going to take a year to settle this case, which is typical. Most automobile accident cases, at least that I've handled, take a minimum of a year, maybe 2 years to even settle, because the reason it takes so long is that you have the accident and then you have your medical treatment. And if, let's say, you have what they call soft tissue injury, let's say your spine is, you don't have broken bones, but you might have what they call herniated discs, or you might have a dislocated shoulder, but no broken bones, and you have to go through physical therapy. Typically, that kind of treatment will last 3 months to 6 months. And so you can't settle the case until you know the extent of your injury. And then once you know the extent of the injury, you got to get your medical records in admissible form. You got to go back and forth negotiations. There might be some dispute about contributory negligence. And easily it takes a year and sometimes 2 years, up to 2 years, to actually settle the case. And you do all that if your maximum recovery is $30,000, but your medical bills are $100,000 that was paid by an insurance company. There's nothing there. So an attorney is most likely not going to take a case like that where he's only going to make $1,000 or $2,000 for a year's work. But there are other cases where if the insurance is huge, like it's a commercial truck, and they've got $1 million coverage, then attorneys are more likely to take that case. That's why when you ride around Houston, you see hundreds of billboards that say, we take serious accidents with commercial trucks. That's what it's all about. It's all about the money. It's all about the money. So attorneys will not take every will only take very specific cases on a contingency basis where they think they can make money. And actually what a contingency fee is, the attorneys, the minimum fees are 30%, 1/3. If a lawsuit is filed, it goes up to 40%. So basically you are in partnership with the attorney on this recovery. It's a partnership. And the attorney is not going to take the case unless they think they can make money in this partnership. It's a very, I'm going to say, it's a very ambiguous relationship. And it makes it's fraught with danger. It's fraught with danger because the attorney is always looking at, am I going to make any money on this case? Am I going to do all this work and come out with just a few $1,000s? That's always on their mind. It's not, it damages I think it damages the legitimate advocacy role of an attorney, looking out for the best interests of the client, because the attorney is looking out for his 30 or 40% interest. It's tricky. Now, for people that have no money, that's the only alternative. And people come to me all the time. Automobile accidents are probably 10% of my practice. I will do it, but I won't look for it. I'll handle it if people that I know, prior clients or referrals from clients, come in with a legitimate case. I don't look for it. I do not advertise it. I'm very suspicious of all these firms that are looking for the big bucks, because most accidents are fender benders. That is the reality of the situation. Most accidents are soft tissue injuries, and you're not going to make big money on soft tissue injuries. You know, the client's not going to make big money, and the attorney's not going to make big money. And a lot of times, a lot of these advertisements always say, you're going to make big money. You're going to make, just to bring in volume, basically. And the reality is, on the firms that do the volume, you're not going to see the attorney. You're going to deal with office staff only, because it's just like a machine that's running. They're going to refer you to the doctors that they know, that they can run up the bills on. I mean, reality. So it's very tricky on contingency. And when someone comes to me and says, I got damaged by my doctor, and I have all these problems, and I'm going to hire an attorney. They're not going to hire an attorney. They're going to want what the reality is they're going to go into a partnership with the attorney, and then the attorney is the one that calls the shots, whether they think this is a viable case, not only for the client but for them. That's the danger, or that's what you have to be aware of on contingency. Nobody is getting something for nothing. Nobody is getting rich all the time, especially if it's a fender bender with soft tissue injury. The person may end up, after you pay medical bills, after you pay the attorney, they might end up with $5,000, maybe $10,000 if there's $30,000 coverage. And so many people to me come in and say, oh, this is going to solve my problems. It's not. And you're going to have to wait a year to get even that money. Now, that's contingency. Now, let me talk about retainer. On the cases where there's a lot at stake, where you have to make sacrifices to actually hire an attorney, pay an hourly rate of $300 an hour. The way it works, the best way it works, is because I don't want to get into a fight to try to collect my fee from the attorney. I'm sorry, from the client. I don't want to have to deal with that. And that's always a problem. You know, a divorce. Oh, I'll take your case. I'll bill you $300 an hour, and I'll send you a bill every month. Chances are I am not going to take that case because I don't know this person. I don't have a history that he's going to pay, he or she is going to pay the bills. I need a little something that when I'm doing the work, when I'm filing the petition and I'm going down for a TRO, and I'm paying the $500 fee, that I'm actually going to get paid for the work that I have done. I don't want to have to be chasing my client around and maybe get paid, maybe I don't get paid. So the way it works for the most part is the attorney will want some money up front. So for example, a divorce. A typical divorce that's contested is going to run you can count on $20,000 if it's contested. If custody is contested, and child support is contested, if property division is contested, reality is it's going to run $20,000, could run $50,000, even for people of relatively minor means. So in a situation like that, most attorneys are going to want some money up front. So let's say their fee is, and you should always get this right up front from the attorney. If it's going to be a place that's not contingency, where you're going to have to pay them, the first question you're going to ask them is not, what is it going to cost? We don't know what it's going to cost. In litigation, if someone says, what is it going to cost? You might as well be asking them, how long is a piece of string? It could be anything. But if it's an hourly rate, you know there's going to be hours and hours and hours. What am I paying each hour? Ask that question first. Even if you can't afford it, at least you're going to know. Maybe some attorneys charge $200 an hour. Maybe some attorneys charge $450 an hour. But at least you've got a number. You might have speak to 4 or 5 attorneys, and so this attorney is this and this attorney is that. At least you know what you're paying by the hour. The next thing is if let's say, like I said, if it's contested, it's going to be at least $20,000. The attorney is probably not going to want $20,000 up front. They're going to want something to get started. So it would be typical $5,000 for a contested divorce for an initial retainer. If the attorney is honest, and all I can do is tell you what I do. If the attorney is honest, you want a substantial fraction that's up front that goes in your trust account. And then you or the attorney or I, which is my regular practice, I send you a bill each month for the work that I've done. So let's say the initial, you come in, it's a divorce, it's $5,000 retainer, it's $300 an hour. And the first month I do the most work. You have to do the petition, you have to draw up discovery, this and that. So maybe the first month is $2,000. And then maybe there's just paper exchange. And maybe the next month is $500. Maybe the court docket is slowed up. Maybe the next month the bill is $0. And so I take that money out of the trust account. I don't have to go, bothering the client or hoping they're going to pay, or what if they don't pay, kind of a thing. You take it out of the money, the initial deposit. Now, if things are going along and the attorney should be informing you what's going on, what problems there are, what additional costs you see coming up within the next 2 or 3 months, keep you updated on a regular basis, keep status reports. And let's say that money goes down to $500, and well, we're only halfway there. We still have to have a hearing, or we have to do a discovery, or we have to do a deposition, and the deposition is going to cost $1,000. Then it's time to renew the money in that trust account. I'm going to need another $3,000 to keep going. And I told you in the beginning it would cost $20,000. I didn't need it all up front, but this is the way the procedure is. If you want to continue on this case, or if you want me to continue on this case. So that's basically how that works. And all of this should be controlled by the representation agreement. Let's go. So anyway, I just gave you an idea of the money amounts that are involved in this. Is not big commercial litigation. This is this is not Exxon suing city services or something like that. This is ordinary. These are problems that ordinary people are going to be facing in their lives at one point or another. Probate problems, divorce problems. These are problems with your job, where you would need an attorney, where you're going to have to pay on an hourly rate. So a lot of people want blinders on this thing here. And so I've had clients where I give them an estimate for a divorce, and I say, I'm going to need $5,000 up front. And they said, I don't have it. And what happens is they don't get divorced. They go on, they leave their family, they have girlfriends, they have other kids, and they don't get a divorce because they don't want to face up to it. But the next thing I hear, this is a real case, not necessarily, not my client. So this lady couldn't get along with her husband. The marriage couldn't continue. The husband worked. Sometimes he worked, sometimes he didn't work. He ended up just staying on the house, sleeping on the couch, taking care of the kids. And she goes on and has other relationships. And I was talking to her and I said, why don't you get divorced? Because you're in this limbo. It's not doing you or any else. Oh, I don't have the money. Next thing I hear, she buys a new car, a new pickup truck. And I see that a lot. People will pay for something to make themselves feel good, but not necessarily what they need. They've got this block. And I don't know, I guess because people would rather feel good. You'd rather spend $6 for a cup of coffee than make a coffee at home and bring it with you to work. So people, so what if I don't have the money? Okay, that's fine. But take a look at what you're doing, where you are spending your money. Maybe you went to Disney World and that cost you $4,000, but you prefer to do that than to screw things down and take that $4,000 and give it to an attorney to get your divorce, or to straighten out a probate problem where maybe your heir property is going to be lost because none of the kids want to pay the taxes. So this is a statement that my mother-in-law said. Really smart person, just really. We talk about this. She says people buy what they want, not what they need, because what they want makes them feel good, and they ignore what they need in the long term for their lives. Just to basically the broader picture they ignore. It's too hard to do. They want something more immediate. People will go, ladies will go to the hairdresser and spend $200, or get their nails done for $200, and then ignore some of the things that they may need that's more important to get their lives together. Next screen. Wait a minute, yes, due diligence. Okay, now, and hiring a lawyer. Like, how do you hire a lawyer? There's at least 20,000 lawyers in Harris County. How do you choose? You've got a problem, you've got a probate problem, or you have, let's say your house is facing foreclosure, or you've got a problem with the assessment on your house, whatever it is. So first thing is advertising. Now, I'm not saying advertising is good or advertising is bad, but advertising, there's no control over what they're saying is true or false. You have no idea. So you've got to take it, like what my father says, a 500-pound bag of salt. It's not worth any more than that. I'm not saying it's worthless, it's not 100% worthless, but it's probably 95% worthless. And I always say, the more somebody advertises, number one, they have the money for the advertising, and I get more and more suspicious the more they advertise. When you see television commercials at night, every 10 minutes, hour after hour after hour, with the same attorney or attorneys advertising, where are they getting all that money to do that? Or you ride along the highway and you see literally dozens of billboards. Where are they getting that kind of money to do that? Is there something here which is a flim flam? I'm just gonna say it's a flim flam. Something's just not right. So be suspicious of advertising. Be suspicious of any advertising. When you've got the advertising for the nonstick pans that are going to straighten out your life, you got to be, or the light, the security light that looks like a camera. Think about it. Just think about it. The next step is website. If somebody doesn't have a website, I am really suspicious. Websites are easy, they're inexpensive, they give information. If somebody doesn't care enough about themselves especially someone who's got a private practice, who deals with people's ordinary problems. Tell your story. It doesn't have to be terribly fancy. Just give information. Say, I've got something to offer. So see if they have a website. And if they don't have a website, that says the most. That means they don't care enough about themselves to even try and tell a story. Now, what's on the website, you can't back up. You don't know if it's true or not, but at least they've taken that step. And it's relatively simple. So I have a website. And if you just, it's on my screen. It's eCline Law no. My website is elliottkleinlaw.com. So I say what my background is. I say what my admissions are. I give a brief description of my work history. And then I have blogs. I have stories, usually related to the cases that I've handled, on all kinds of cases, and advice. This is what I think I can maybe offer people. They can take it or leave it. But at least I put some effort in to tell my story. And it's based upon my experiences. So you've got to take a look at a website and don't depend on it. Don't depend on advertising for sure. The website, take a look at it. See if it gives you information that you can use rather than just saying, I'm the greatest, or I'm a super lawyer, or something like that. See if it gives some meat, something that you can, some advice that you can actually use and take. The next step is check with the state bar for disciplinary actions. If somebody has been censured, or if they're on probation, something like that, that information is there. At least that'll take all this is these are little pieces that build up and build up. So if somebody is on probation, you probably would want to avoid them. That's something, don't avoiding trouble is actually of value. When you go and you talk to the attorney, ask them if they have a trust fund to put the money in. The money that you give them, if it's not for past earned fees, if it's for future fees, or if you were going to have a settlement and it's going to be divided up between the doctors and you and the attorney, and the court reporter and the expert witness, ask them if they have a trust fund. Ask them what bank, ask them the account. And because almost all attorneys are required, if they deal with money that is not earned already, if it's money that is held for a third party, they're required to have a trust fund. So ask them that. Ask them if they have, if you're going to hire them on an hourly basis, how often do they do they send out billing statements? That's really important, because the billing statements will set forth what they've done and what expenses on a regular basis. That's a good way of keeping track of what's being done on your case. And what I'll do is I'll do that on a regular basis. And if in a month I haven't done anything, I'll send them a zero billing statement, at least letting them know that I didn't do anything. I mean, be straightforward about these things. That's really important. That's a good way of keeping track of someone. And of course, if you look at it, you don't understand it, you can always call the attorney. And make sure you talk to the attorney and not office staff. Ask them if they have professional malpractice insurance. I think that's real important. That means that you want to protect your reputation, and you will be more careful when you have insurance, because you don't want to claim against your insurance, because then your insurance rates go up. So, I have legal malpractice insurance, but that's a good indication that is an indication of how much an attorney values his own reputation and his own work. Because if someone doesn't have insurance, it's like, hey, if I get sued, I don't have anything. You're not going to get anything from me. I mean, that kind of mentality is not someone you want to trust an important issue that's important to your life. You want someone who values themselves, and having legal malpractice insurance is an indication. It doesn't guarantee it, but it's an indication. It's all part of the thing. It's like having a website that shows you care about yourself and how you present yourself. Next thing, attorney representation agreement. It's basically required for a contingency fee, because the state bar rules basically say that you can't have a fee splitting. It's a fee splitting agreement, and it's gotta be spelled out very carefully. But on the hourly rate, I have seen plenty of attorneys. You call them up and say, I've got a problem. I want you to take care of this, this, and this. And they'll say, okay, it's $300 an hour. And I'll send you a bill. And that's it. Nothing in writing. I mean, I'm talking about, I was on the board of directors of my homeowners association. And I was not going to represent the homeowners association because I was on the board and it's a conflict. But we hired an outside counsel. And we said, we want to change our deed restrictions. And we're going to have a vote, and we're going to need some advice. And they said $300 an hour, and they never gave us a representation agreement. That to me is crazy. You've got to have a scope. You've got to have an agreement. What am I going to do? At the very least. So if there's a dispute, at least you have a writing, something in writing that sets forth, I will do this, this, and this. And I won't do this, this, and this. I'll represent you to collect on this debt. But I am not going to represent you if it has to go to an appeal. That sets limitations, and it's, of course, it sets what the hourly fee is. It sets if there's a retainer. It sets if the retainer is used up, what the renewal replenishment is. It sets forth what expenses are expected. You're expected to pay expenses. It sets up if the expenses exceed a certain amount that you're going to have to get your client's permission. I mean, I have it. If it's more than $500 expenses, I have to get my client's agreement on that. It sets up a whole bunch of limitations. So if you're going to hire someone on an hourly basis, you've got to get a representation agreement. Absolutely. Absolutely. The other thing is you always have to ask them, and this is contingency fee or the hourly rate, especially contingency fee, because they have what they call case managers, which are they're just office staff. And all they do is they make sure you go to their doctor. If you're hurt for an automobile accident, their job is to make sure that you go to the doctor, you go to their doctor, because they've got relationships. I'm going to say to run up the bills. There's no doubt about that. And they want the bills to be run up so they can get so they can get as big an amount, whether you're terribly hurt or not terribly hurt. And if there are any questions, you never see the attorney. The office staff will get all the documentation together. We'll do the negotiation. And you might have a final conversation with the attorney. Oh, they've offered X number of dollars. I suggest you take it. But if you have any questions, you're always going to be talking to an office staff. You want some indication what is the accessibility of the attorney. And you have a right to make a beef about that. If during the representation that is not that they don't comply to what the representations are. So these are some of the things. Now, of course, is the old-fashioned thing, a referral from a family friend, family member or a friend who's had a probate, or we use this attorney to write the will. I think he or she can do the probate part. That makes sense. You had some relationship. Or if, let's say, somebody had an automobile accident and they had a good experience, and somebody else in the family or a friend, you can get that referral, and you can get an idea of how that person was treated and how you can expect that he'll be treated. But if it's cold call, if you had an accident and you get a card from the record driver saying, here, use this so and so, walk, don't run away, because that's going to be a referral. And then, but it might be an illegal referral system. So when choosing attorney, it's more like what to watch out for than a positive way. You know, on TV, they advertise, you've been in an accident, we have a list of attorneys who will take your case. And of course, there's going to be kickbacks involved in that kind of thing. I avoid problems like that. Just avoid problems like that. And it's okay to if you Google, you know, searching the web and Googling is actually pretty good. So if you say, let's say you were involved in an automobile accident, you don't know who to turn to, you can't. The main thing is, if you know somebody who's been in an accident, talk to them. Say, who did you use? How was that experience? There's, you know, chances are there's going to be somebody in your family or some acquaintance that had to use an attorney, either for a divorce or for a probate problem or for an automobile accident problem, and ask them who they used and how was that experience. At least that's a start. And then you could check the advertising, the website, check for disciplinary actions, see if they have a trust fund, see if they got medical malpractice insurance. But at least you got started. It's not like, ooh, I'll just call the person who's at the top of the Google list for automobile accident cases, and never go to the top, because those are paid advertising. Those are paid advertising. When I look for a contractor or for anybody to do some work, I'll go down below the advertising section to the place where they actually list their names, and click on their website, see if the website looks decent, kind of a thing. And you can start down there. Go, you know, get off of the paid advertising. All right. Next, I think we're at the end. Okay, questions. Let's see here. Nia, can you let me see here. I'm going to go to the chat box here. I'm going to go try if I can.
Okay, let me go back to the beginning. There were a couple. I have to stop for a second so that I can get to the question box.
Okay. Let's see. I've got a real estate question here.
Yeah,
Okay.
my husband died without a will. The court probate in Houston determined that I own 50% of the house, and the other 3 people own less percentage of the same house. I want to sell, but one person does not. What is the legal process that I need to start?
Okay. The husband did not have a will, correct? So this is going to be what they call a dependent administration. Go back to the ruling of the court in setting forth who owned the property. There'll be a judgment setting forth the heirship, what they call the heirship determination. If the one person is holding out, you're going to have to get an administrator appointed in this case. Go to the attorney who handled the heirship determination. Tell them the problem, that you think you're going to need an administrator to make an application to the court for a court order to sell the house, if one of the people is not cooperative. If they're not cooperative, you're going to need a court order, and you're going to need an administrator, and it'll probably be a dependent administration. So talk to the attorney who handled the original heirship determination. That's my advice. Oh, how lengthy and how much would it cost? It's okay. I'll tell you. It's probably going to cost, I'm going to say, roughly $5,000, maybe anywhere between $5,000 and $10,000, and that money would probably have to come out of the sales price. You could probably work something out, but the attorney will probably want something up front, just like what I talked about before. Would want a retainer. I wouldn't be surprised if they might want to retain. Hey, you'd have to work this out. This is just pure guessing on my part. Maybe $3,000, and then work out if the rest of it can come out of the sales price.
And I also let this person know that the inherited property and clearing title for inherited property and other probate concerns, that workshop is scheduled for Thursday. So the attorney there actually goes into a little bit more detail of what happens and what that process is like too.
Mm-hmm.
Okay.
Next
Um,
question,
there's some direct,
medical, let's see, medical question.
okay,
Okay, I get all kinds of calls on medical issues. I mean, all kinds. And when I did I did 30 years of workers' compensation. I've seen every operation, good, bad, and indifferent. What if right after a knee replacement, I was given medication that I was allergic to, and no one noticed that it was acting weird? I said things to the nurses that were out of character, and it didn't raise any red flags. By me being non-medical, I didn't know. I was sent home on a similar medication, double the dosage, that caused a chemical imbalance and has caused severe anxiety, depression, and PTSD. It has been over 2 years since this happened. Is there anything I can do now? Statute of limitations for medical malpractice is 2 years. You've got a real problem here. What I would do would be just Google medical malpractice attorney. Tell them the story, see if they're interested in following up. And talk to more than one attorney on this thing here. It looks like this situation would have a lot of problems. I'm not going to say it can't be done, but I'm just going to say it's a lot of problems. So just talk to, I would say, 4 or 5 attorneys. The other thing is that the way the medical malpractice works is that you call up, you tell your story, you're going to talk to an office staff person, and they have certain criteria that they will, because medical malpractice is so difficult now to win, they will only take things that fit in very small, very narrow categories. Most of the time, they're going to say, call the state bar. But what I would do, if it was me, I would call and I'd say, I want an office visit, or I would walk into the office. There really is something to be said for being a pain in the neck. It's not pretty, but you've got to use every option available to protect yourself. And it may not be successful, but at least you've exhausted all possibilities. Let's go on to the next one. Does Harris County have property surveys on file? I'm having a property dispute with my neighbor and they are threatening civil action. How can I get a copy of my property survey at no cost to me? Well, you need to take a look at the property records, the deed records. There might be a survey there or there might not be, but you have to basically do a title search to see if there's a survey. If it was me, and if I can search the property records myself and I can figure this out most of the time. But if you're just a lay person, call a title company with this question. They're going to charge you. They might charge $200. They might charge $500. But if the issue is important, it's worth the $500. But call a number of title companies and say you want to see if there's a survey of your property in the real property records.
and then I also suggested, depending on how long they've actually been in the house, to go back to the title company where they actually closed.
Yes.
So generally, if it was recent, I don't know how long title companies actually keep their records, but if it's something that was fairly recent, a title company should have a copy of the title if one was ordered during the closing.
Yeah.
But otherwise, I know that the county usually doesn't keep a copy of the whole survey on file or anything like that.
Right. And the other possibility is have a survey done. Contact a survey company. I think that charges roughly $500, I believe. And don't hold me to it, but I think it's something like that. This is going to cost some money, not an outrageous amount, and depends on what's at stake, if it's worthwhile.
Okay, there were a couple of other questions that were sent directly to me.
Okay.
Let's see. Can I be sued because my neighbor complains about my puppy barking? The same neighbor is telling me that I cannot park my car next to the border of my and his property. Can he sue me?
Okay, so anybody can sue anybody for anything. So when someone says, I'm going to sue you, my response would be, go ahead. We'll work it out in court. I can't stop you because, and that is the truth. Anybody can sue anybody for anything. I can't give you, and now if you're going to say, is there an ordinance about this, about barking dogs? Well, if someone is disturbing the peace, you can always call the police. If they're complaining about your dog, it's up to them to do something. I think for the most part, they are, and there are some volunteer, there used to be some volunteer organizations to basically resolution of neighbor conflicts that don't raise to the level of having police action or filing a lawsuit. Nia, are you familiar with that? I know they used to have
It's Harris County that has an arbitration or mediation department. I can try to find the name of it exactly, but I know it's through Harris County Dispute Resolution Center. That's what it's called. It's Harris County Dispute Resolution Center.
Right.
But
So-
that's on the neighbor to actually file that kind of a complaint, if I would imagine.
Mhm. Yeah. So, it's really up to the complaining neighbor to take an action. You can't tell a person, you can't do this. Because people can do whatever the reality is, unless they're committing a crime and you call the police and have them arrested, you really can't stop people from doing something. It's very, very difficult.
The second part of that question is regarding the car. The neighbor's telling me I have to keep at least 5 feet distance from the borderline. Is
Okay.
that accurate?
Right. So if a person is complaining about, you can't do this, you can't do that, I would simply ask them, show me the ordinance. Go to the city, get the ordinance and show it to me. Put the onus on them to do an action, rather than just saying, you can't do this, you can't do that.
Especially if you're parking on a public street. I don't know that they can tell you that you can't park so far. And Myra, are you still available to potentially answer that question? I'm not sure that they can tell you how far from in front of their house or next to their property line.
Well, the only ordinance I know that's close to that is that you have to be like less than 12 inches from the curb.
Yeah.
I'm sorry, can I specify my question?
Okay.
Yeah, so I'm not parking my car on the street. I don't have a driveway. So I'm parking on the grass area, which I have a semi garage outside. It's just a piece of roof.
Like a carport.
Exactly. So I'm parking outside of the carport on my grass area because I don't have a driveway, which is next to his property. And he's telling me that I cannot be that close to his driveway, that I have to have a 5 feet distance between the border and my car parked there on my grass. So,
Right. So the only restrictions might be either an ordinance or a deed restriction. And I would ask the neighbor to give you that documentation of that. And then it's up to them.
In addition, also, if it's your property that you're parking on and you're not actually encroaching on his property line, I don't know that he could tell you that you can't park on your own property.
that's how I feel.
Well, tell him to prove it. How about that? Prove it.
Thank you very much.
Yeah.
Thank you.
And I will send you that link too. I see your email. Okay, there was another question that was emailed earlier. What is the statute of limitations for suing a contractor who has been working on my house for over 6 years and still hasn't finished? He says that he is out of business once 90% of the work of the money is gone.
Okay, a couple of things. Number one,
Years and hasn't finished.
first thing is you got to find out if there was a written contract. That may or may not be of significance, but at least get started with that. So the contractor, oh, you, the contractor's been working on this for 6 years, has not finished. Couple of questions. How much money has the homeowner paid? What percentage of the work has been done? If you have a written contract, you may have some rights. Without a written contract, there's just too much stuff up in the air. If you've been paying somebody for the work they've been doing as they go along, you've gotten value for what you've paid, even if they haven't finished the project. I don't think there's without a written contract, I don't think you have any rights to compel someone to finish a job. That's what it is. If the contract says, and it's all over the place. If the contract says $8,000 to put in a driveway or to build a garage, $8,000, and you've paid $8,000, and the garage has not been finished, and he's still working on it, and the contract's got to say that the work will be completed within 6 months. Or if you've paid and you haven't gotten what you wanted, I think for sure you can. As long as the work is on a continuing basis, you don't have a statute of limitations problem. If there'd been a violation and there'd been more than 4 years, typically it's 4 years for a written or an oral contract. But if the work is still continuing, then the violation has not accrued, basically, has not been finalized. So if he's still working on it, you don't have to worry about the 4-year statute. The 4-year statute is after the breach. And if he's still working on it, there hasn't been a breach where the statute starts running.
Ah. So until he actually finishes, that's when the
Well, no. If he walked away and it's been more than 4 years since he walked away, see, if he walked away, then that's the breach right there. And then you have 4 years from when he walked away.
Okay.
Okay. So if it's been more, if he comes back every couple of weeks and he nails up a few more things and he pours a little bit of concrete and then he comes back, and if it's been less than 4 years since he last came back, you may have a chance. But this is probably a case for small claims court.
Okay.
Most likely.
Now, regarding what is considered small claim, like what's the dollar amount up to?
$20,000,
$20,000.
including attorney fees.
Okay, so what's the process if somebody wants to represent themselves again in a civil action? Like, how do I even start the process, or what do I need to do?
All
If I decide I want to sue my neighbor, or if I want to sue whomever, what's the process?
All right. So what you'll do is, I believe there's 5 county precincts. Commissioner court precincts in Harris County. And so what you do is you go to the JP court in that precinct, and you can just Google, Harris County Justice of the Peace Courts. It'll give you a list. And even if you call the wrong one, they're going to ask you. You say, "I need to sue so and so. This is his address. Is this the correct court?" The clerk will tell you if it's the correct court or which the correct court is. They'll give you an address, they'll give you a phone number. You got to know the name and the address of the person that you want to sue. I would go to the JP court, the proper JP court in the district where the defendant lives. You say, "I want to sue this person for breach of contract." The clerk and I want to represent myself. And the clerk will give you a form. And you put in the name, your address, the person's name, address, what the cause of action is about. Could be a breach of contract. It could be a collections item, whatever it is. You pay the fee, which I believe is $150 for, to file it, and includes the constable's fee. They will forward it to the constable. The constable will go out to the person's house and serve them. And you will probably have to follow up to find out when the person was actually served. They have to file an answer. I believe it's the first Monday after 20 days that they were served. If they don't file an answer, You go back to the clerk, you say, I want to get a default judgment. They'll set it down for a hearing. You tell the judge the story, the person hasn't filed an answer. The judge will say, judgment for $8,000 against this person. We'll probably enter it. Now, then you have your judgment, and then you can file that, an abstract of judgment in the property code against the property. Or if the person answers and says, I don't owe you anything, blah, 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 then what you could do is you'll go back to the clerk and say, the person's answered, I need a hearing before the judge. Or if you want to, you can get a jury trial, which I really don't suggest in JP court. And there'll be a hearing that'll be set. You'll go there, there'll be 50, 60, 70 people, the room will be packed. And the judge will call each case and say, do you think you can settle this? If you can't, I want you to go in the corner there and see if you can work something out. If you can't work something out, I'll listen to your story after I hear all these other 70 people. And then you just tell us it's Judge Judy. Just watch Judge Judy. That's exactly how it works. The judge will ask you questions, you'll tell your story, present your evidence, and the judge will make a decision right there.
So if it's,
Did I answer your question?
yes,
Okay.
so if it's above the amount for small claims court, then what's that process? Is it?
Okay, then if it's above 20,000 but below 250,000, then it should be filed in county court, and that's much more formal. You have to follow the rules of evidence. I would suggest you get an attorney for court.
Okay. All right, making sure that there are no other, HOA is neglecting to perform maintenance and refusing to respond to HOA document request. What's
Okay.
that process?
All right, I see that all the time. The way the statutes work is any dispute about an HOA or the deed restrictions will say what the obligations of the board is and their bylaws. If they are violating those bylaws, or there's actually the property code also has a whole bunch of new stuff now, last few years, limitations. That can be filed, county court has the jurisdiction over those disputes. But for any dispute with the HOA, because it's so technical, I would, even if it's filed in a JP court, I would suggest an attorney be used.
Okay. And those were all of the questions that were emailed to me. So I believe that's about it. Again, to the participant that asked about the airship property, again, more details about that one will be presented in the workshop that's scheduled for Wednesday. And also for everyone that has registered to participate, I will be sending out a copy of the link of this recording for everyone. In addition to the questions also will be provided as well. I will also look for the contact information for the Harris County Dispute Resolution and attach that reference in the email as well. So if you guys have any other questions outside of that, then please feel free to contact myself or Mr. Elliott. I did put his contact information in the chat for you all in case you're interested in contacting him directly with questions. But Mr. Klein, we want to thank you very, very, very much for taking the time out. You were extremely thorough. Really appreciate it. Always a wealth of information from you, a lot of detail that we don't know about. And I didn't know that that the attorney referral company, the organizations, our partners, that if it is a cash remedy case, is that what you say? Is that what you call it? A cash remedy? Like if you're
income generating.
If it's an income generated case, that they can't take those kinds of cases, those civil legal cases.
That's right.
Okay, all right. I wasn't aware of that. Okay, but good to know. So we now won't keep referring people. Oh, you can contact them. They can cover that for you too. Okay, so no, that is not the case. So good to know that. But again, thank you very much for taking the time out this afternoon. We hope everybody is able to remain dry and safe in spite of all of this rain and weather that we're getting and anticipated to get throughout the rest of this week. Ms. Myra, thank you for joining us. We hope that you all have a wonderful remainder of your afternoon. Take care of yourselves, be safe, and we hope to see you again next time. Is there anything else you'd like to add, Ms. Myra?
No, just don't forget, we have coffee and conversation in Acres Homes on May 23rd. So we hope to see you all there and to have some coffee and some conversation, and let's discuss about some of the concerns that you have. Thanks, everyone.
It's been a
All right.
pleasure. Thank you.
Thank you, Mr. Klein. All right, you all have a wonderful afternoon. Take care of yourselves.